Okay, thank you very much for having me today. I'm going to present today a report that has been produced by my organization, the International Labour Office. We received a mandate for from our tripartite constituents to investigate on non-standard forms of employment. Now, non-standard forms of employment doesn't coincide precisely with precarious work. There are some forms of employment, non-standard employment, like part-time, for instance, that is perfectly stable. If it's correctly regulated, it's not precarious. And we also see that some workers in the SER, some standard workers in the standard employment relationship, may well be precarious. So the two concepts are not the same, but if non-standard forms of employment are not properly regulated, they might very well be considered as precarious. So the forms of work that we treat in this report, which is an interdisciplinary report, so it's been produced by lawyers and economists. This is an outline of the report, and the report is available online. It can be downloaded for free from the ILO website. We basically try to define non-standard employment, and we focus on four main categories of non-standard employment. The first one is temporary employment, that includes fixed-term work, but also includes casual form of employment. We have part-time work, so every form of work with reduced hours, but also on-call work, so workers that can be called on demand, like zero-hour workers and other forms of casual arrangements. We investigate the fiscalization of the workplace, so agency work, multi-party employment relationships such as subcontracting, supply chains, franchising, and we also look into the what we call disguised employment, so basically bogus self-employment, when a worker is deprived of the protection that are due to him because the contractual relations is mixed classified, and dependent self-employment. Now, dependent self-employment is genuine self-employment that still can be attached to a very limited or just one client, and therefore may be dependent from that client. And one of the several jurisdictions around the world regulate in a way or another these forms of dependent self-employment. An example is Canada, but also Italy. And in this category, we also include workers in the gig economy that might be fall into this gray area between employment and self-employment. This is a breakdown of what I just said, and we started working on this project because we realized that there might be some problems for these workers to accede to fundamental workers' rights. The first one is freedom of association and collective bargaining. If we start from the featured workplace, people that work at the same workplace but for several entities might not be able to come up together to bargain collectively because they might be regarded to be not jointly employed by the principal company. So they might be in situation in which they cannot bargain collectively together. Some workers, especially self-employed workers, might be outright excluded from acceding to freedom of association. This may happen in many cases for fear of being in breach of antitrust regulation. So if self-employed come together and do collective bargaining, they might be regarded as in breaching competition law and producing price fixing. And we found that workers and unions report very strong problems with the possibility of organizing these workers, because in some cases they might be afraid of joining unions, might be afraid to engage in collective bargaining or in collective action because their contract is temporary and they might be not renewed at the end of the spell of time. So this is for freedom of association. We also found problems with regard to discrimination, particularly of self-employed people that are in many cases excluded from the general application of labor law and therefore not included also in the protection against discrimination at the workplace. And this is particularly serious because normally women, migrant workers, minorities are overrepresented in the non-standard workforce. So if we look at the distribution around the world of men and women in part-time, we see that women are much more present in part-time. And actually, as I said, these groups of workers are overrepresented in all the forms of employment that we examined. We try to come out in chapter 6 of the report with some of the measures that can be adopted building on the experience of the ILO member states, so basically almost all the member states in the world, all the countries in the world. We divide a regulation part from a supporting policy part. You may find out more of that in the report, but today I'm going to address the legislative responses, what can be done at the legislative level to make non-standard work better. And starting from these 6 category of measures that came out from the international experience. And the first one is ensuring equality of treatment. So in many jurisdictions around the world, there are regulations that introduce a non-discrimination principles between non-standard and standard workers. So you cannot be discriminated in pay or working condition just because you are in a fixed-term work or a temporary agency work or just because you are a part-time worker. Of course, this is not and panacea. There might still be practical problems of enforcement of the equality of treatment principle, but in many jurisdictions of the world, we found these non-discrimination policies being adopted. Another important set of protection is for marginal part-time workers, or workers who work very short hours, or workers who are engaged in on-call and casual work, so they have no guaranteed minimum hours. Now, in some countries, particularly in Europe, there are regulations that try to stabilize the hours of work after a certain period of time towards the average of the hours worked in a reference period. To try to stabilize the income of the workers in these forms of work. In some cases, minimum notice periods are provided for on-call workers to be obliged to answer to the call. And in many jurisdictions in Europe, but also in some states here in the US, the reporting time pay has been introduced. So if you report for work, if you're called for work and you report and the shift is cancelled, you don't lose the whole day because you are at least paid a certain amount of hours. These have been found in the US, but it's also a policy in several European countries and also in some developing countries. And going to the employment misclassification part, the employment relationship recommendation of the ILO sets out some principle to avoid disguised employment relationship. The first one is the primacy of fact, so basically the substance needs to prevail over the form. If the contractual arrangement says that I'm self-employed, but I work as an employee, I need to be recognized as an employee, I can apply for reclassification. And this is a principle that is adopted basically in most jurisdictions of the world, so it's nothing really revolutionary. Some countries allow a broad range of means for determining the existence of the employment relationship. What does it mean? That in the definition of employment, they use multi-factor tests, so they don't just focus on the control test, because the control test might be under strain because of new business practices, but also when the control test is still very relevant. Some courts in Europe, particularly in Italy, have adopted a broad interpretation of the control test, so you don't need to be micromanaged to be regarded as meeting the control test. In some countries, a presumption of employment is provided for workers in general, or where some indicator exists. For instance, you have fixed working hours or a fixed remuneration, you work at the workplace of a given employer. In other countries, an intermediate category of worker has been introduced between employment and self-employment. Now, I know that this is a topic of discussion here in the US as well, particularly for the gig economy, and in the discussion, if you want, we can also discuss why I think this wouldn't necessarily be a good idea, particularly for the gig economy. Other policies are the restriction of the use of non-standard employment. So, for instance, banning non-standard employment for permanent needs, for core needs, or limit the duration of fixed-term contracts, temporary agency work, and casual forms of employment. This chart shows that a good deal of countries in the world prohibit the use of fixed-term contracts for permanent tasks. Another set of policies regards the fiscalization of the workplace. So many countries in the world adopt joint and several liabilities in temporary agency work. So if the user firm or if the agency doesn't pay the wages, the user firm is held responsible. The same happens with subcontracting, and in some cases it also extends to the subcontractor, so the principal company is held responsible for the supply chains of contracts, and so they are incentivized to record to reliable providers and contractors. A system of shared liability in occupational safety and health is basically provided in many countries in the world. Australia is a very positive example of extending the protection of occupational safety and health much beyond the scope of the employment relationship, and also including subcontracting, franchising, and supply chains in general. Of course, in the US, you have the question of joint employment, and we report that the National Labor Relations Board has eased the requirement under which you can be regarded as a joint employee in subcontracting and temporary agency work. Finally, the way to ensure freedom of association and collective bargaining for non-standard workers. First of all, the removal of legislative barriers. So, in many countries of the world, self-employed people were allowed explicitly to bargain collectively, overcoming the antitrust problem. In some cases, some steps have been adopted to ease the possibility of having solidarity collective action. If I am a worker of a subcontractor, I might need support from more stable workforce from other entities, from workers of other entities, and when sympathy strike, solidarity strike is prohibited, that could be difficult. So in some countries, particularly in South Africa, some interesting occurrences are reported in the report. And as well, the prevention of discrimination in non-standard employment. If I am a temp, nothing says that the provision that bar discriminatory dismissal for union reason also regard non-renewal of contracts. So in some cases, in some countries, this non-discrimination, non-retaliation measure have been extended to cover non-standard workers, and particularly the non-renewal of temporary contracts. And thank you very much.
It's always good to be specifically informed on how far behind the United States actually is.